He said, I didn't do it. It was heartbreaking to listen to this boy say, I didn't do it.
I'm Brad Davis. Last August 21st, an 83-year-old woman named Clara Haas was brutally murdered in her second-floor apartment in this building at 976 State Street in Springfield, Massachusetts. Her body was found the following morning by her daughter-in-law, who called police. Within an hour or so, the police arrested a suspect, the building janitor, 28-year-old Russell Daniels. Daniels was questioned for 7 hours before he signed a confession, which turned out to be the sole piece of incriminating evidence presented by the state at his trial. It was apparently enough to convince a jury of his guilt, and he was sentenced to life in prison. On the surface, a routine murder case, but beneath the surface, some questions. You see, Russell Daniels is retarded. He has the mental capacity of a second grader. He is, in the words of an authority on mental retardation, a 9-year-old boy in a 28-year-old's body. And so today in Massachusetts, we have a 9-year-old in Norfolk Prison. Russell Daniels did not have a lawyer during the 7-hour interrogation that resulted in his confession. During his trial, he was represented by attorney Joseph Hickerson of Springfield. John Sablon spoke with Mr. Hickerson.
All right, Mr. Hickerson, would you recount the facts of the case?
Well, the facts of the case is that a person without doubt was killed. They picked up Russell Daniels for it, and the Commonwealth had no case except a confession, which I contended then and contend now was illegally obtained.
What do you mean illegally obtained?
I mean that it was not obtained according to law, which must be freely, voluntarily, and intelligently made. And the circumstances and evidence in this case prove that this confession was not freely, voluntarily, and intelligently made.
Let's talk about that confession. What can you tell me about that?
Well, the confession was obtained after Russell had been detained there approximately 7 hours without food, without drink, and without even going to the bathroom.
How about an attorney? Did he have an attorney?
He did not have an attorney there at that time. He never had an attorney the whole time he was in the police station. He never had the counsel of friends. His mother and his father, his brother, and his his cousin, went to the police station looking for him because they had discovered by television that he had been arrested.
His family?
Yes.
Had to hear about it on television.
That's the first they heard of it, that he had been arrested, and at that time he had been arrested for some several hours.
Well, doesn't the police department normally notify the next of kin?
No, but they are supposed to give you what we call the Miranda rights and the privilege to use the telephone and to get in touch with someone. And they state that they did this. And Russell said that this was done after he had signed a confession. But there is uncontradicted evidence that before this confession was signed, that a friend by the name of Mr. Bisson, who had spoken with the detective that morning, had gone to the police station and got no cooperation. And that these other 4 people had gone there and went to the information desk and got no cooperation.
By cooperation, what do you mean?
Well, they just wouldn't let either of these people see Russell.
Russell Daniels was picked up and charged with murder by the Springfield Police Department. Where were you? When did you find out about it?
I was in district court that morning. One of my residents was testifying for the state in a case that was before district court. One of the police officers, Officer Bryans, came up and asked me if I had knowledge of somebody living in the area of our halfway house. And he described somebody who sounded to me like Russell Daniels. He asked me some questions about Russell at that time. For instance, whether I felt Russell was capable of committing a violent crime. And I said at that time that he was as capable as the detective or I were of committing a crime. I couldn't make a categorical statement of that type. He asked me if I wanted to be present when Russell was picked up for questioning, and I said I did. I felt that there was no way that he could be questioned by himself without having somebody there to help him. Officer Bryans called the station, and at that point they had already picked up Russell, and I had to go back into the courtroom with the case that I was involved in at that time.
Now, Alto, how did you first hear that Russell had been arrested?
My cousin George, he came by my house one day on August the 22nd, and he told me that my brother was arrested. And first, I hardly believed him, but I thought I'd better check out the story, so I called down to the police station. And they told me, no, we do not have a Russell Daniels down here.
What time did you call the police station?
Oh, I say around 4
in the afternoon,
something like that.
And they said they didn't have Russ there?
Right.
What did you do then?
Well, I just got in my car and drove over to my father's house and talked to him and asked him, have you heard anything about it? And as I was coming in, he said, yes, I just heard it on the news. So from there, we proceeded down to the police station.
What happened at the police station?
Well, when we got down there, approached the front desk and started asking them about, do they have a brother down there? They started giving us a roundabout answer. Matter of fact, the officer at the desk at the time said something in effect of, I just got up here, I don't know if Russell's here or not.
Did he check the records to see if Russell was there?
No.
He just left it at that?
Yes, really just left it at that.
And then what happened? How much time, did you ever get to see Russell that day?
No, we did not.
How much time did you spend at the police station?
About approximately 10 to 15 minutes, just hanging around, trying to figure out what's the next move.
Were you able to find out if Russell had an attorney with him?
Russell did not have an attorney. The following day, when we saw Russell in district court, we found out there was no one with him doing the questioning.
Mr. Ryan, is it unusual for someone to be questioned without legal counsel present?
No, it is not. Not here nor any place else in this country. For the provisions of the Miranda case, which of course has received a tremendous amount of prominence, means merely that the person who was either accused or who was brought in to a police-oriented atmosphere and is to be questioned about a crime is alerted to certain rights that he has. These are called the Miranda warnings. They consist of 4 or 5 of these. There's a card which is carried by all of the police, which is read to the prospective defendant or suspect. And he then is informed that he does not have an obligation to talk with him, that he can have a counsel present at that particular time. It's his prerogative to have one. If he says no, then it's an obligation of the police. It's an obligation of the police to, from that point on, question him as to find out what, if anything, this man knows about the particular crime.
But what if he didn't understand those rights that you just talked about?
Well, let me say this. If a crime committed, a person has been killed, the obligation of the police is to do everything they possibly can to make a determination as to who is a likely suspect or who might possibly be the one or probably be the one who committed this particular crime. They have an obligation to talk to anyone who can give them this information. If they have a suspect whom they think might have done it, their obligation at that particular time is to give him his warnings. It's not for them to be psychiatrists and make a determination. That's at a later stage for someone to determine. But they notify this man, if and when they apprehend him, of his rights. They make a determination at that particular time whether he understands, at least as far as their layman's knowledge of intelligence is concerned. They make a determination as to whether or not this particular person understands and there is a competent waiver, as far as they're concerned. Now, maybe not a judicial one, maybe not as far as a jury is concerned, or a psychiatric evaluation, but they've got to act on the moment. They can't let this person go and say, well, why don't you go out and get a psychiatrist to examine you, and then come back in and let me know if you want to answer these questions. They've got to act when the pursuit is fresh. And this is exactly what a policeman will do, and he's got an obligation. If he gives a Miranda warning and he makes a determination that this person understands what he's talking about, then they've got an obligation to go further and question if this man does not want to have counsel present. And that's what was done in this particular case. And I certainly can't fault those police. I thought they did an excellent job in what they had to do at that particular time.
What did they say to you at the police station, Russell? What did the police officer say to you?
Oh, they started questioning me about.
Did they read anything to you before they started questioning you?
No. No, they're supposed to read their rights. They said they did, but they didn't.
Mr. Ryan, Attorney Hickerson and Russell Daniels himself claim that the Miranda rights were not read to Russell before the interrogation.
Well, let me say this, and I certainly am not casting any reflections on Hickerson or Daniels. All I'm suggesting to you is that this is not the first time. And may I suggest that in many, many cases where a person is convicted, they say that the Miranda rights or the Miranda warning was not given to them.
Did they ever ask you if you wanted somebody there with you?
No, they didn't ask me nothing. They just brought me down there to the police station and started questioning me.
When the detectives were questioning you, when they were asking you questions, you must have told them something because they wrote this down, Russell. Did they read this back to you?
Yeah.
They read it back to you. Well, if they read it back to you, did you understand that you had said you would kill somebody? You must have known what it said if they read it back to you, Russell. It's all typewritten here that you killed that lady, and your name's signed on the bottom. Now, why did you sign? If they asked you and you said you didn't do it, why would this be a confession that you did it? And why did you sign your name?
Why did you sign that paper, Russell?
I didn't know what I was signing.
You didn't know what you were signing?
No.
They didn't tell you?
No.
Do you know what a confession is?
Statement.
A statement. Do you know beyond that? Do you know what a confession is? A statement of what?
A crime.
Did they tell you that it was a confession?
They didn't tell me until I got done signing it.
Well, what made you sign it?
Oh, they told me if I signed, they'll let me go.
And if you didn't sign?
They'll lock me up. I mean what I said.
So you signed it because you didn't want to be locked up?
Yeah.
How long was Russell Daniels questioned by the police department, by these two detectives?
To my knowledge, he was there somewhere around 7 hours.
There was no lawyer present.
Not to my knowledge.
I have shown you the confession, which was the only piece of evidence that the state had in the conviction of Russell Daniels. Could Russell Daniels have written this confession?
From my knowledge of Russell, no.
The first line of the confession reads, "I have been fully advised as follows, that I have a right to remain silent, that anything I say may be used against me in a court of law, that I have a right to advice of legal counsel and to have an attorney present while being questioned, that if I cannot afford an attorney, one will be provided for me at the Commonwealth's expense. If I am to be detained, I have been warned of my right to use a telephone, to make one call, to contact friends, arrange for bail, or engage an attorney." Now, could you tell me what I have just read to you?
All right.
Do you understand what the words say?
What is a legal counsel, Russell? What is advised? What does the word advised mean, Russell?
Do you know what engage an attorney means?
A lawyer?
That's an attorney. Do you know what engage means?
How about Commonwealth?
When did you find out what rights are, Russell?
I used to watch it on TV on Perry Mason.
What do you know about your rights? Will you tell us what are your rights?
I know some of them, but not all of them.
What are they, Russell?
You have a right.
You have a right to remain silent.
Anything you say will be against you. With a court of law.
Did you remain silent, Russell?
Down there?
Yes.
Yeah.
Could Russell Daniels understand that sentence?
I think it's very questionable if he could.
Could he read this?
No. No, I think that was demonstrated at the trial.
Well, if he couldn't read it, and if he couldn't write it, who wrote it?
I don't know.
Well, it's got two detectives' names on it. In your opinion, who do you think wrote this confession?
I can't give you a definite answer to that, although I think it's very much impossible for Russell Daniels to have written it.
It's impossible for him to have written
I
this.
think that it's impossible for him to have written it, right?
This is the paper you signed. Can you read any part of that down there?
Start right here, Russell.
Wait, right here.
That's right. Good and loud.
Yes.
Just read the words that you know.
Yesterday.
Yesterday, I was
Russell, what I tried to have you read is your statement of confession, the one you signed. Now, did they ask you to read it before you signed it?
Yeah.
They did. Did they ask you if you understood it?
Yeah.
What did you tell them?
Yeah.
You told them yes? Why did you tell them yes if you couldn't read it?
No.
You told them no, and they still had you sign it?
Yeah.
All right, Russell, the statement says that on August 21st, you went to the deaf lady's apartment and you took a knife and you stabbed her with it. Did you do that, Russell?
No, I didn't.
Have you ever been in that lady's apartment?
Never been in an apartment. Never.
Did you know her at all?
No.
Did you ever ask why the police had taken you and questioned you?
Because I was a janitor in that block.
That's the reason?
Part-time.
That's the reason that they arrested you? You really did it, didn't you?
No, honest. That's the guys on the show.
Somebody told you to say that you didn't do it, didn't they?
Nobody told me nothing. That's the truth. I never did nothing like that. Never.
When the police officers read the rights to Russell Daniels, the word advised is used, the word legal counsel is used. And Russell Daniels told us he couldn't understand these words. We read these words to him, and he didn't understand. So therefore, would he understand what the police officers were reading to him?
Well, obviously he's intelligent enough to convince you that he didn't understand what these words meant, so he must have some persuasive powers. But assuming that this is so, that what you say is so, The time to test it, of course, is before a judge. They're the ones that make a determination as to whether or not legally this should go to the jury. And this is done, a motion to suppress. And I talked about a voir dire hearing. Defense counsel files a motion to suppress, meaning they want to suppress the confession. A voir dire hearing means to have this hearing out of the presence of the jury, so that the judge alone is the determining factor as to whether or not this confession should be submitted to the jury for their consideration. There was such a hearing in the absence of the jury before Judge Hare alone. And he, after a long hearing, made a determination that the Miranda warnings were in fact given to Russell Daniels and that he made an intelligent waiver. And therefore the confession was read to the jury and they were to bring it to the jury room for their determination.
Mr. Hickerson, I have here a 273-page transcript of a motion to suppress evidence. Now, can you explain what that is?
That motion to suppress evidence is one of the rudiments of procedure that we go through when we feel that the Commonwealth has certain evidence that should not be used in the case, and that it was not obtained properly, and that should not be made a part of the Commonwealth's case. And in this case, we're talking about the confession. And in conference, it was admitted that if that confession went out, the Commonwealth would have no case.
You said in conference, but you're saying that the admission was made that if that confession were not allowed, there would be no case?
The Commonwealth would have no case.
At that point, whose decision was it to allow that confession? The judge's?
Yes, it's always the judge's decision. We call it voir dire here. This stack of paper that you have here, this is a pre-trial hearing that we call a voir dire. Mm-hmm. And it's on the motion to suppress. Now, it's entirely within the discretion of the judge as to whether or not that motion to suppress should be allowed or denied. So, in his discretion, he allowed the confession, so we went to trial.
You felt pretty confident that this motion to suppress was going to be successful, weren't you?
I was willing to gamble on it.
Once the judge had decided that there would be a trial, that the confession would be allowed in as evidence, did you feel you were in trouble?
No, I didn't. I had a 16-man jury there, and I thought that, okay, we had a second chance, and I was willing to take that chance. I never felt in trouble about this case until the jury came back with a guilty verdict.
Were you confident that Russell Daniels is guilty?
I don't make that determination, sir. All I do is present evidence to the jury in as competent a fashion as we can. The grand jury indicted him. Therefore, it becomes incumbent upon us under our oath of office to present the case in an adversary proceeding. He was represented by counsel. We presented the case. It's for the jury to make a determination. First of all, of course, it's for the judge to make a determination as to whether or not, as a matter of law, the case as presented by the district attorney's office or the Commonwealth should be submitted to the jury for their consideration. This was done by Judge Hare. There was a motion for a directed verdict as a matter of law. There was a hearing on it, and he denied the motion. Thereafter, the case was presented to the jury for their consideration.
Sworn testimony in court said Russell Daniels' reading level was equivalent to that of a second grader.
All right. What can a second grader read and understand?
Well, here is a second grade reading book, and I'll read one paragraph, and you'll notice that most of the words are concrete terms or terms that could easily be explained or demonstrated to a youngster. It was time for Farmer Field to pick up the corn on his farm.
Would you read what's written on that page?
It was time for farmers.
With a bang and a bump, the big ears of corn fell into his little gray truck.
Now tell you what, Russell. Read any of the words that you know. All right? Forget the words you don't know. Read the words you know.
Yeah. The corn on his farm with a bag of corn far into his little gray truck.
At last there was no more room in it. So Farmer Field started off to town with his corn.
At last there was no more room in it. So farmers set off to town with his corn.
Let me ask you something, Russell. From what you've read, can you tell me what that story is about?
Well, the farmer.
What about the farmer? If you don't know, don't be afraid to say you don't know. You don't know.
Now, Russell Daniels was questioned for several hours by two detectives of the Springfield Police Department, and he signed a confession. All right, let's say that he didn't write the confession, but couldn't he have related the story to the detectives and they just wrote down what he said?
This is possible.
You have a copy of the confession, and there's a couple things I'd like to ask you. There's one word here, a waiver. I just want to read it to you. I understand my rights. I am willing to answer questions and make a statement. I do not want a lawyer. I fully understand what I am doing. No promises or threats have been made to me, and I freely volunteer to make the following statements. Now, if this was explained to Russell Daniels, could he understand it? Could a second grader understand it?
I think it would be difficult, but even more difficult or impossible, I feel, are some of the words that are in the paragraph above. For instance, I have been fully advised. It's possible to explain that, but it would have to be explained. Rights. Rights is a term that I feel would be very difficult to explain. Court of law, legal counsel. These are all words in this paragraph up here.
But you mentioned legal counsel. Couldn't the officers explain to him that was a lawyer, that was someone who could help him?
Well, even lawyer wouldn't mean anything unless you explained it. Why would he need a lawyer? How do you explain all this to somebody? I think it would be very difficult. I don't know how I would do it. I don't know how I would do it with my youngster who reads at about, well, not quite that reading level, but has roughly the same IQ. I don't know how I could do this.
What would the reaction of a retarded person be after a 7-hour questioning period?
I don't think they could tell you, I don't think a person could tell you his own name after that.
You're talking about a retarded person
Right.
now. Could Russell have signed the confession then and not know what he's signing?
I believe it's possible.
We've been told by the president of the Hampden County Association for Retarded Children, Sally Barnhart, who has a retarded child, that a person such as Russell Daniels would be so confused that he wouldn't even know his name after such questioning. Now, this is what she said.
Listen, I respect her very much. Believe me, I do, and I know exactly what she's trying to do. But assuming not to be so, don't you think that if you were defending this case, or if you were involved in this case, that you would put a Sally Barnhart on the stand, or even would you not have put a professional man on the stand to have testified to that, who may have in some way influenced either the judge or the jury? That's not my prerogative. All I had to do in this particular case was to submit to the court a report. This man was examined at Bridgewater. There was a determination by psychiatrists, qualified psychiatrists, who submitted a report to court.
Mr. Ryan, what was the psychiatrist's report from Bridgewater?
Well, let me say this. There's an obligation on the part of the Commonwealth to have this man examined before he goes to trial. Not as to what his state of mind was at the time that the crime was committed, but whether or not at the time he's going to stand trial, whether he's competent to stand trial, means can he aid in his own defense? Can he help to prepare the case? That's all it means. That's the requirement of the Commonwealth, and that was done in this particular case, and the psychiatrist said that he was competent to stand trial. And so therefore, once that determination is made, a date is set for a trial, and he was set up for a trial date, and we went to trial, and he was convicted.
Who was the prosecutor in the actual trial?
John Tian.
Mr. Ryan, what evidence did the state present in the Russell Daniels trial?
Well, I couldn't recite all of the evidence that they presented, but of course, in the normal case of presenting a murder case, we had the autopsy report, we had the report of the medical examiner, and all of the things that are necessary to prove that the person was killed, the knife, where it came from, and a statement from the defendant in this particular case.
How much of that evidence could be termed incriminating?
Well, it's all incriminating.
Directly incriminating.
Well, it's a question of direct evidence, of course, would be someone who saw a particular person kill another or commit a particular crime. That's what's direct evidence. Everything else is circumstantial because no one sees them use a particular knife, but if the knife is consistent with a wound, if it comes from someone's house, this is a circumstance which, together with other things, leads to a conclusion of guilt.
But the confession had more weight than other things, didn't it?
I don't know. That would be for the jury to decide, but I would assume, as disinterested party in this thing, that it was one of the convincing factors.
The confession was signed, Mr. Ryan, by a retardate who has a mental capacity of a 10-year-old. How creditable could the confession be?
Well, it was creditable to the extent that the jury gave credence to it and found him guilty. I can't answer that question because I don't know upon which particular facts the jury made its determination. I can't invade their province, and I can't speculate as to what they thought of in the jury room. But in any event, they certainly must have given it some consideration.
In your opinion, without this confession that Russell Daniels signed, would the Commonwealth have had a case?
In my opinion, no.
Well, I understand that the confession was the only piece of evidence.
This is my understanding.
Well, when all this was going on in court, Mrs. Barnhart, what were your feelings? The mother of a retarded child, approximately on the same reading level as Russell Daniels?
I felt it would be very easy to confuse any retarded person in a situation like this. I could think that Russell understood that whole thing. He might say, yes, yeah, I understand, when he didn't understand a word. This could happen.
Mr. Ryan, how would a retarded person act after several hours of questioning?
I haven't any idea. I've never interrogated a retarded person. But let me ask you this. Assuming all of these things are so, assuming that this particular person doesn't understand the word lawyer or legal counsel or advise or anything else, how would he act? If this boy was sufficiently retarded to not understand anything at all, then how in God's name was he going to cope with the open world? Why wasn't he still in that institution? Who released him? Check with him and find out why this boy should be out on his own, fending with society, when in fact, everybody now says the poor kid couldn't cope with society, yet they put him back out in society to make his own way. Somebody else is responsible as far as that's concerned. That's not our concern. Somebody else let this man out and said he is able to cope with society and to make his own way in this world. They said this. They let him go. Of course, when the police pick him up, they don't pick him up as a retarded child. They pick him up as a suspect in a murder case. And they interrogate him as they do anybody else. And when they make a determination that he has an intelligent waiver, they then ask him questions. Whether or not he did intelligently waive is up to somebody else to determine. But the police did their job as they saw fit. Query as to whether or not this man should have been released from the institution without some sort of guardianship.
Mr. Tremblay, Russell Daniels spent 13 years at Belchertown State School. In fact, we're standing in the kitchen where Russell worked. How well did you get to know Russell Daniels?
I worked with Russell Daniels extensively for 1 year as a rehab counselor, and then carried out a relationship with him more as a friend while I was in a teaching position here at the school.
What kind of person did you find him to be?
Very quiet, likable, didn't mix in to any extent in social activities, had a few friends, but didn't get in any trouble with anyone either.
As well as you know Russell, did he make any progress while he was here at Belchertown?
He made a great deal of progress in the vocational area, but not a great deal in the academic area.
Who decided that Russell should be released, and what was the reason?
The decision to release anybody is done by a team, which would consist of rehab counselors, the medical doctors, social workers, psychologists, educational people, all the different disciplines on the grounds.
And the reason for his release?
The reason for his release was because that we felt he was ready to go out and live independently in the community.
All right, now, is Russell Daniels capable of coping with the outside world, in your opinion?
Yes. Russell Daniels showed in a year of independent living that he did very successfully and was able to cope with the aspects of independent living.
Mrs. Barnhart, during the trial, how did Russell Daniels seem to be reacting? Did you notice that?
Yes, he was very calm. He sat very quietly.
We understand that his brother, Alto, was with him. Is this true?
Yes.
Did they communicate? Did you notice that they talked to one another during the trial at all?
A little. I wondered how much Russell really understood about what was going on around him.
Attorney Hickerson asked my brother to read it. Confession, he could not. And then Attorney Hickerson read the confession to my brother. He asked him, "Do you understand what I have read to you?" My brother said, "Yes." He said, "Well, fine then, explain to the jury." My brother could not. He couldn't say a word because he did not understand. During the whole trial, I sat next to my brother because my brother didn't even know what was really going on. Even when the jury was being selected, he was asking, "What are these people here for?" I had explained to him what's the procedure. He kept on asking me what they're going to do next. When are they going to let me go? During the trial, when the officer was on the stand testifying, my brother kept on saying to me, "Why are they lying? Why are they doing this to me? I haven't done nothing."
Mrs. Barnhart, how was Russell on the witness stand?
Calm. He said, "I didn't do it." It was heartbreaking to listen to this boy say, "I didn't do it."
What would a retarded person think of a proceeding like this? What kind of a reaction? Does an institutional setting, an institutional bringing up, so to speak, have anything to do with how they would react in a court of law?
I think it would be very important because in an institution, you are more or less trained to respond to authority. You are trained to please. In fact, most retarded children seem to sense their dependency on other normal people. And aside from being mischievous, and very often will try to do what you expect of them and are quite intuitive about this. It's very easy for them to want to say yes to you many times, just particularly if they are feeling at a disadvantage. If they're in over their heads, they know it right away, so they have to say yes to everything. because they feel that they're safer saying yes probably than saying no.
The confession that Russell signed, do you think that he could read and understand the language in the confession?
During the court trial, a testimony was accepted from Mrs. Geraldine Baker, who would be considered a reading expert, and she said that Russell would not be able to understand the vocabulary that was in that statement.
Could it be possible that Russell Daniels was intimidated or felt intimidated so that he signed a confession admitting to a crime that he didn't commit? Is that possible?
In my opinion, it's entirely possible.
On what do you base that opinion?
On my knowledge of the retarded people who are in the institution, of institutional behavior, and of expectations of what might occur in a pressure situation.
All right, would you explain that for me, please?
Certainly. There are occasions within an institution where it becomes more convenient for a person to confess or admit that they have done something and take a little responsibility on themselves rather than to prolong an issue which would harm them and their peers. Harm not physically, but procrastinate an uncomfortable situation.
Isn't it possible then that Russell could have said, yes, I did it, and he didn't do it?
It's possible. At one time, in a halfway house, some money was missing. 5 of the residents confessed to taking it, the money. Not one of them had been involved. It was some other person that wasn't even living in the house.
These were retarded
Yes.
people?
Yes.
Why do they do this? Why would they do something like this?
They don't always understand the situation, and they sometimes want to get out of where they are. They don't want to be questioned. They're uncomfortable. They just want to get it over with. Whatever is going on, so they'll say yes or no or whatever they think the right thing is to say, just to get away from this uncomfortable situation, even though they have nothing to be uncomfortable about.
There's something that struck me while we were talking with Russell. He seems to have a decent memory. Now, is that consistent with his retardation?
He would have a good memory to things that he's been very frequently exposed to. Yes.
Do you think that Russell Daniels could have committed this murder?
No, I don't.
Do you think that Russell Daniels should be out in free society?
Yes, I think he should.
Would you trust Russell Daniels around your wife, around your children, around your mother?
I wouldn't feel badly having Russell Daniels live next door or right in the same house with myself.
Should there have been a trial in the first place?
I really don't see how the case went to trial, because the confession is all the evidence that the Commonwealth had. They had no fingerprints of Russell anywhere in that apartment. They had taken bedstands, backboard. They had taken the Vaseline jar that they say he used. They took the knife that was found in the lady's throat. They took an object from the medicine cabinet, the door, and sent it all down to Boston for fingerprints. And by the Commonwealth's own testimony, Russell's fingerprints were not found on anything, anywhere in that apartment or on any objects that they had sent down.
At the trial, Mr. Ryan, the Commonwealth produced no witnesses and no fingerprints. Is this unusual in a murder trial?
Fingerprints. Fingerprints you find on TV. You make a study of case histories in the United States and you'll find that 99 and 9/10 of the cases are never solved by reason of fingerprints. Fingerprints are a wonderful thing for making identification on people after they're arrested and so forth. But I had a case, I recall, it was about 14 years ago up in Pittsfield, and we found thousands of fingerprints in an apartment, but they were not identifiable fingerprints. And so when people say fingerprints, they mean identifiable fingerprints that you can make a determination from the print that it was done by a particular person. Now, you find evidence of fingerprints, but they're all smudged. You know they're fingerprints, but the ridges have been rolled over, and you can't make a determination. And in 16 years, since I've been a district attorney, with some fairly competent police personnel in the city and in Greater Springfield and in the state police. One case in all of the cases that we've had was determined by a fingerprint.
Mr. Hickerson, the victim, Mrs. Haas, was white.
That is correct.
The accused, the convicted, Russell Daniels, is black.
That is correct.
Was race an issue?
I don't feel so up until when we got to the jury. Now, I can say this, and I don't mind, I'm not pulling any punches. I believe race might have been an issue so far as the original investigative authorities were concerned. So they all let a white woman allegedly killed by a young black man, but I don't want to make that an issue, but it could very well have been. There was rumor that there was someone else going about in the community who, in a moment of weaknesses, testified that he had committed this crime that Russell was being incarcerated for. There are people who implicated that they had heard this conversation, and I just don't think the matter had been thoroughly investigated. And I feel that after Russell had been arrested, that the Commonwealth decided to throw up its hand in regard to further investigation.
Well, relative to this other person, the person who admitted that he committed the crime, was the prosecutor's office notified? Did you tell them?
Yes, I told them.
And their answer?
Well, they interviewed two people whose name I gave, who was supposed to have had information. But I have no knowledge that they interviewed this person who Russell's brother and friends actually had picked up and delivered to the police.
They had picked the person up and taken the person to the police?
They apprehended the person, notified the police in Winchester Square, told them why they had apprehended him, and that person was arrested because that was an outstanding charge for something else. And he was kept overnight at the York Street jail. And I also notified the Detective Bureau that the reason we were interested in this person was because he was supposed to have confessed to this crime. And when we got down to court the following morning, as we were walking into court, we had discovered this person walking away. And he had been released on bail for another crime, but he had not, to my knowledge, been interrogated about the crime that Russell was supposed to have committed. So all I can say is that was a hell of a communication gap between the Detective Bureau and the police department. There was either that or there was blatant disconcern for the rational administration of justice.
Mr. Hickerson, to the best of your knowledge, where was Russell Daniels at the time in question, the time that Mrs. Haas was killed, let's say?
Well, according to the autopsy report and the medical, which is the medical examiner's report, at the time of the incident on the 21st, Russell was supposed to have been down at City Hall picking up applications for a civil service job. But he's supposed to have seen Mr. Bisson and got some assistance in filling out the application.
On August 21st, the day of the murder, did you see Russell Daniels?
Yes, I did. I saw him a number of times during the day. He had come over to see me initially in the morning to help him fill out a civil service form. He was applying for a job at a local hospital that is under civil service.
How about the times, Mr. Bisson?
I saw him originally around 9:45 in the morning. I was on my way to do something else, so I asked him to come back that afternoon at 1 o'clock.
And he had gone several other places that day, according to testimony, uncontradicted, including Howard Johnson's on Columbus Avenue.
On August 21st, 1972, we've been told that Russell Daniels and his cousin George were at Howard Johnson's around noontime. Is this true?
Yes, it is.
How could you remember?
Because it was a chicken fry on a Monday, and George came in, which I used to work with him, and he asked me for a pencil for this gentleman, and he said that he had to write out his application because he couldn't read or write. So I gave him a pencil. And there is a woman who comes in every day about 10 after 12 to get 4 copies to go, and she had just left.
So that's why...
I remember it was around noontime.
How long were they there?
Oh, maybe a half an hour. About half an hour.
So you're saying they got there about 10 after 12 because you remember that a woman always comes in and gets 4 cups of coffee around that time. So a half hour, about 1:45 they left.
Right. Yeah, about 1:45, maybe 20 minutes of 1, something like that.
You're positive of
I'm
that?
I'm positive. And I can, they were sitting on the end stools.
I saw him then about 1:45. And again, I was involved in doing something since he had been late, and I had asked him again to come back later in the afternoon. He came back several more times during the day. In the afternoon, somewhere around 3:45. And in the evening, he dropped over to see some of the other men that I had with me, and again later on in the evening. So he was over the house a number of times during the day.
Miss Pepe, you have placed Russell Daniels at Howard Johnson's on Columbus Avenue in Springfield. The time that the testimony stated a murder was being committed. If you had this information, why didn't you come forth?
Because I don't really read the papers, to tell you the truth. I see so many people, and sometimes I don't even want to be bothered. But if I would have read the article, I would have called someone. But I never saw it until after they said they convicted the fellow, and that was all I ever thought about. You know, I heard of the murder, and that was it.
Would you have testified if somebody had asked you?
Yes, if someone would have asked me.
You know, you see a lot. You must see a lot of faces,
Oh.
Miss Pepe. But how can you possibly remember Russell Daniels and George?
Because George used to work with me, and we were talking about Louis Daniels, who used to work with me also. And that's how I remembered that name, because we used to work together. And he said, I think that Louis was his cousin. Louis was this Russell Daniels' cousin.
What kind of a day was it?
It was a very, very hot day. Very hot.
On the chance that Miss Pepe might have confused Monday, August 21st with another Monday near that date, we checked Springfield weather reports to determine if there were other very, very hot Mondays around the 21st of August. The weather reports show that the 21st was indeed hot and humid. The 14th of August was cloudy with a high of 68. The 7th had showers with a high in the 70s. The 31st of July was overcast with a high of 74. And the 24th of July had a high of about 80 with wind gusts around noon. Russell Daniels was in jail on every other Monday after August 21st. So out of 5 Mondays, the day of the murder was the only Monday that could be described as very, very hot.
In sworn testimony, the coroner stated that the murder was committed around noontime, with leeway on either side of noon, on August the 21st. We have found a waitress who works at a Howard Johnson's on Columbus Avenue who told us that Russell Daniels and his cousin was at Howard Johnson's at that time on August 21st, and she was never even called to testify.
Well, that's not our job. Now, let me say this. I want to tell you in fairness that whenever we make a determination or on a discovery that there is someone who is helpful for the defense, we always disclose this information. There may be people who differ, who hear this show and may differ. But this is not so, because we've done it in the past, and lawyers who have been recipients of this know that we do it. I know that I've done it personally in many cases. If I find a witness that I think may be helpful, I normally turn it over to these people if I make a determination that they're telling the truth. But as far as this witness is concerned, I know nothing about her. I'm sure that no one in my office knew nothing about her, and this is a late discovery. If this is so, and if her story can be verified, then I think there's an obligation on the part of defense counsel who represent Russell Daniels to move for a new trial on the basis of newly discovered evidence. Our law isn't blind. There are many alleys that you can go up to fight this matter, and certainly the appeals courts are open. Our courts are open if there is newly discovered evidence. But this is the right of defense counsel. They can take this path if they so desire. I don't know this witness. I don't even know her name now, and I would assume that the defense counsel knows her name, and certainly it's an obligation on his part to do whatever he can for the defendant, and I hope he does.
Mr. Hickerson, you represented Russell Daniels in the trial. The trial ended. He was found guilty. and sentenced to life.
Yes.
And you had a certain amount of money to work with. You had a certain fixed fee. You're still on the case. Why?
I'll live with it till I die.
Are you going to appeal? Are you appealing?
Yes, we are.
For a new trial?
No, sir, we don't want a new trial. We feel the case is won. We feel there's an error of justice here on the part of admitting that confession, which was not intelligent, freely, and voluntarily made. And that's all the evidence that the Commonwealth had. We think it had no business in the case, so I don't want a new trial. I want the whole ball of wax.
There is then some hope that the Russell Daniels case is not closed. He has a chance, through a new trial or an appeal, to have the guilty verdict reconsidered. We've tried to tell what happened to Russell Daniels from the day he was arrested last August by talking to everyone involved. Only the police declined to be interviewed. As we have shown, there is evidence that Daniels was seen in various places at the time the murder was committed. The testimony of the Howard Johnson's waitress is new evidence, and in the opinion of the district attorney, it may be grounds for a new trial. We have also determined that Russell Daniels had little understanding of the confession he signed, or of any printed material for that matter. A jury found him guilty. This program, we believe, demonstrates in the least reasonable doubt about that verdict. For Brad Davis, I'm John Sablong. Good night.
I feel very strongly that if retarded people are going to be living in our community, and many of them are capable of doing this, that they need some extra protection under the law that a normal person does not need. Supposing you were arrested and somebody read this, "I have been fully advised of my rights," in Hindustani to you.
I wouldn't understand
You
it.
wouldn't understand it, all right. But they could say, well, we advised you of your rights. But you could say, yes, but I didn't understand what was being said to me. I feel a retarded person is somewhat in this predicament. And it's not always easy for the person talking with him to understand how much he understands.
The preceding program was a Channel 3 Public Affairs presentation and was pre-recorded.
Here is Leonard J. Patricelli, president of Broadcast Plaza Incorporated, with a WTIC editorial.
Phrases like equal justice under the law and the rights of the accused have a hollow ring after watching this program, The 9-Year-Old in Norfolk Prison. We do not know if Russell Daniels is guilty of murder. Our documentary did not set out to prove his innocence or guilt. That is something far beyond the scope of tonight's television program. But we did seek to raise questions about the fairness of the treatment this retarded young man has received. What we learned and what we have just shown to you convinces us that Russell Daniels did not receive equal justice under the law. We cannot believe that this retarded young man fully understood his legal rights at the time of his arrest. We cannot believe that he understood the confession he signed, and we therefore must conclude that his defense was doomed from the start. We hope that this program supports those who seek to have the guilty verdict reconsidered. Further consideration may prove Russell Daniels' guilt, or it may prove that we have an innocent 9-year-old in the Norfolk prison.
The preceding was a WTIC editorial by Leonard J. Patricelli, president of Broadcast Plaza Incorporated. Responsible opposing viewpoints will be considered. Copies available on request.